これよりパネルディスカッションを開始いたします。テーマは、知財分野の国際的動向、知財分野の専門裁判所が果たす役割です。では、パネリストの皆様をご紹介いたします。増田実、知的財産高等裁判所部総括裁判官。野中松夫、特許庁審判部審判部長。ハン・ギュヒョン、韓国知的財産高等法院院長。クラウス・グラビンスキー、欧州統一特許裁判所控訴裁判所長官。米国連邦巡回区控訴裁判所裁判官、レイモンド・チェン。相良百合子、中村合同特許法律事務所弁護士。黒川恵、安倍育保片山法律事務所弁理士。岩井直之、知的財産高等裁判所裁判官。以上の皆様でパネルディスカッションを行います。それではここからの進行をモデレーターの岩井裁判官にお願いしたいと存じます。よろしくお願いいたします。
はい、ありがとうございます。それでは主催者合同企画のパネルディスカッションを始めたいと思います。最初のテーマは知財分野の国際的動向になります。まずは海外からご参加いただいている裁判官の方々からそれぞれ10分程度で各国の裁判所における最新の状況を紹介していただきたいと思います。ではまず最初に韓国知的財産高等法院のハン委員長、よろしくお願いします。
皆さんこんにちは。존경하는 심포지엄 참석자 여러분, 만나 뵙게 되어서 반갑습니다. 저는 대한민국 특허법원장 한규현입니다. 존경하는 와타나베 일본 최고재판소 대법관님과 내외 귀빈을 모시고 일본 지적재산고등재판소 설립 20주년을 기념하는 국제 지재사법 심포지엄에 참여하게 되어 무한한 영광입니다. 지금부터 대한민국 IP 사법제도의 지난 20년간 발전한 내용에 관해 말씀드리겠습니다. 대한민국 지식재산 보호제도와 관련하여 먼저 말씀드리고 싶은 것은 대한민국은 최상위법인 헌법에서 지식재산 보호를 명시하고 있습니다. 헌법 22조는 저작자, 발명가, 과학기술자와 예술가의 권리는 법률로서 보호한다 라고 명시하고 있습니다. 이러한 헌법 정신을 바탕으로 대한민국 IP 사법제도는 지속적으로 발전하여 왔습니다. IP 사법제도의 주요 변화로는 1998년 아시아 최초의 IP 전문법원인 특허법원 설립, 2002년 민사 중복관할 시행, 2010년 전자소송 시행, 2011년 비밀유지명령제도 도입, 2015년 IP 허브코트 추진, 2016년 IP 민사 전속 관할 및 침해 증명에 필요한 자료 제출 명령 도입, 2017년 국제 지식재산권법 연구센터 설립, 2018년 국제재판부 도입, 2019년 구체적 행위 태양 제시 의무 및 고의적 침해에 대한 정액배상 제도 도입, 2021년 영상재판 확대 시행 등을 들 수 있습니다. 신검 및 관할 법원은 전속 관할인 특허권 분쟁을 중심으로 말씀드리겠습니다. 법률심인 대법원을 최종심으로 하여 민사소송은 3심, 특허심판은 처분의 적법 여부를 다루는 행정소송은 2심의 심급구조로 되어 있습니다. 민사소송 1심은 6개 지방법원에서 담당하고 있습니다. 전국을 관할하는 서울중앙지방법원은 2017년부터 4개의 IP 재판부를 운영하고 있고 현재 13명의 법관과 11명의 기술조사관이 있습니다. 특허법원은 민사 항소심과 특허심판원의 처분에 대한 행정소송을 담당하고 있습니다. 17명의 법관과 22명의 기술심리관 및 기술조사관이 있습니다. 상고심은 4명의 대법관으로 구성된 3개의 소부 또는 대법원장 및 대법관 12명으로 구성된 전원합의체에서 담당하고 있습니다. 대법관 업무를 보조하기 위하여 6명의 IP 전담 재판 연구관과 6명의 기술조사관이 근무하고 있습니다. 다음으로 대한민국 사법부의 발전된 디지털 환경과 국제적 사법 접근성을 말씀드리겠습니다. 전자소송은 2010년 특허법원 행정소송에서 처음 시작되었고 2011년에는 모든 법원의 민사소송으로 확대되었습니다. 금년 형사전자소송의 시행으로 대한민국 사법부는 모든 소송이 전자소송으로 되었습니다. 당사자는 시간과 장소에 구애받지 않고 실시간으로 전자소송 기록에 접근할 수 있고 소송 자료를 온라인으로 제출하고 열람할 수 있습니다. 도면, 소스코드, 동영상 같은 디지털 증거도 전자 형태로 제출할 수 있습니다. 위에 있는 2개의 사진은 전자장비를 갖춘 법정 모습입니다. 왼쪽 하단 사진은 전자기록 뷰어입니다. 대한민국 사법부는 그동안 영상재판 활성화를 위한 준비와 노력을 계속해 왔습니다. 2021년 영상재판의 확대 시행으로 내국인은 물론 외국인 당사자도 공간적 제약 없이 온라인으로 참여할 수 있는 재판 환경이 구축되었습니다. 지금 이 사진은 영상재판의 모습입니다. 외국인 당사자의 사법 접근성을 높이기 위하여 2018년 서울중앙지방법원과 특허법원에 국제재판부를 마련하였습니다. 국제재판부에서는 영어 등 외국어로 변론할 수 있고 외국어 서류를 번역문을 첨부하지 않고 제출할 수 있습니다. 동시 통역과 판결문 번역도 제공하고 있습니다. 외국인 당사자는 법정에서 자신의 모국어로 재판부와 소통할 수 있고 해외에서 원격으로 영상재판에 참여할 수도 있습니다. 지난 9월 24일에는 특허법원에서 진행된 재판에서 해외 거주 당사자가 온라인으로 변론에 참여함으로써 당사자의 국제적 사법 접근성이 더욱 제고되었습니다. 특허법원의 재판 역량과 국제적 경쟁력을 강화하기 위해 설립된 국제지식재산권법 연구센터는 소송 절차 안내 및 판결집을 외국어로 발간하고 주요 판결을 영어로 번역하여 와이포 플랫폼에 공개하는 등 IP 재판 실무를 외국에 널리 알리고 있습니다. 대한민국 사법부는 효율적인 심리를 할 수 있는 전문법원 및 전담재판부를 운영하고 있고 전문성을 갖춘 법관을 배치하고 있습니다. 2016년부터 특허법원에 장기간 근무하는 고법판사 제도의 시행으로 법관의 전문성은 더욱 강화되고 있습니다. 법관은 기술을 이해하기 위하여 기술심리관과 기술조사관 등 내부 기술 전문가와 협업을 하고 있습니다. 그들은 다양한 기술 분야의 전문가입니다. 특히 기술심리관은 특허법원 행정소송에서 기술적인 사항에 관하여 소송관계인에게 질문할 수 있고 재판에 합의해서 의견을 진술할 수 있습니다. 내부 기술 전문가의 도움만으로 해결되지 않는 고도의 전문 지식이 필요한 특허 분쟁에서는 외부 기술 전문가인 전문심리위원을 활용하고 있습니다. 전문심리위원은 다양한 기술 분야의 전문가로 구성된 780여 명의 전문가 풀에서 지정되고 있습니다. 전문심리위원은 기술 쟁점에 관한 설명을 하고 소송 관계인에게 질문할 수 있습니다. 때로는 법관이 기술 사항을 이해하기 위하여 전문가를 정인으로 신문하기도 합니다. 법원은 지식재산권의 효율적인 보호와 특허 침해 소송의 충실한 심리를 위하여 비밀유지 명령제도, 자료 제출 명령제도, 구체적 행위 태양 제시 의무 제도를 활용하고 있습니다. 법원은 영업 비밀이 포함된 서면이나 자료를 심리하는 경우에 당사자의 신청에 따라 상대방 당사자에게 소송 목적 외의 사용 또는 공개를 금하는 비밀유지 명령을 하고 있습니다. 또한 법원은 당사자의 신청에 의하여 침해의 증명 또는 침해로 인한 손해액의 산정에 필요한 자료 제출을 명할 수 있습니다. 그리고 법원은 특허권자가 주장하는 침해 행위의 구체적 행위 태양을 부인하는 당사자로 하여금 자기의 구체적 행위 태양을 제시하게 하고 있습니다. 나아가 침해 행위가 고의적인 것으로 인정되는 경우에는 침해 행위를 한 자의 우월적 지위 여부, 고의 또는 손해 발생의 우려를 인식한 정도 등을 고려하여 인정된 손해 금액의 3배를 넘지 않는 범위에서 배상액을 정할 수 있습니다. 작년 8월부터는 5배까지 가중 배상할 수 있게 되었습니다. 특허법원은 2016년 마련된 소송 절차 안내 규정을 지난 2025년 7월 11일 전부 개정하여 사건 초기 단계에서 진행하는 절차 협의, 자료 제출 명령 과정에서의 비밀 심리 절차 등을 상세하게 담은 민사 항소심 표준 심리 절차를 마련하여 복잡한 특허 분쟁에 관하여 예측 가능하고 신속 공정한 재판을 도모하고 있습니다. 최근에는 심결 취소 소송에서 법원 내부의 절차가 국민의 재판 청구권을 보다 충실히 보장할 수 있도록 제도를 정비하는 노력을 하고 있습니다. 대한민국 사법부는 급변하는 기술 환경 속에서 당면한 여러 과제를 슬기롭게 극복하고 세계 최고 수준의 IP 재판을 이루고자 계속 노력해 나가고 있습니다. 이상으로 IP 사법제도의 지난 20년간 발전 내용에 관한 설명을 마치겠습니다. 경청해 주셔서 감사합니다.
範囲長ありがとうございました。それでは続きまして、欧州統一特許裁判所控訴裁判所のグラビンスキー長官、よろしくお願いします。
Good afternoon. It's a pleasure being here in Japan, and I'd like to take the opportunity to congratulate the IP High Court to its 20th anniversary. I'm the president of the Unified Patent Court. It opened its doors just a little more than 2 years ago. So in terms of a human being, the IP High Court is a strong young adult, while the UPC is still a little toddler. So we can learn a lot from the IP High Court at the UPC, I'm sure about this. Let me start giving you an update of the Unified Patent Court as it stands right now. The Unified Patent Court is a court common to currently 18 EU member states. So unlike a classical court that is a court for one country, this court is a court for currently 18 EU member states. In other words, I could say it is the court of Austria, it's the court of Belgium, and I could name all the 18 member states that take part in this court. On this slide, you see a map of Europe, and you see all the UPC member states in the dark blue color. You see also the medium blue color. These are EU member states that have signed the UPC agreement but yet have not yet ratified the agreement. And then you see more EU member states in a light blue color. These are the states that have neither signed nor ratified the agreement, but they are all invited to join the Unified Patent Court if they like. Here you see the structure of the UPC. It has a court of first instance with currently 13 local divisions spread all over the UPC member states. It has a central division that has its seat in Paris and has sections in Milan and in Munich. And it has one regional division, which is a division that is shared by 4 UPC member states, the Nordic-Baltic division, and there, by the way, the language of proceedings is only English, but I come back to the languages in a second. There's a Court of Appeal, and I'm the president of the Court of Appeal that is located in Luxembourg. And like any other court in the EU national court, also the UPC has or may make referrals when it comes to the interpretation of EU law to the European Court of Justice, when it is relevant for deciding the case and the questions are not clear or clarified by CJEU decisions. And there, this system is also complemented by a patent mediation arbitration center, which is called the PMAC. It is currently not operational, but it will be operational very soon next year. So all preparations are on track in that regard. What about the jurisdiction? Let me first address the subject matter that the court has jurisdiction on. It is about infringement and the validity of European patents, classical European patents. As you may know, they are bundled patents. Once they are granted, they give the effect like a national patent in all the member states of the European Patent Convention, provided the European patent has not been opted out. And it has also jurisdiction on the so-called unitary patent, which give unitary effect in the UPC member states. What about international jurisdictions? And that is currently much debated, so that's why I like to focus a bit on this issue. The UPC has jurisdiction in case it is about infringement, alleged infringement of a European patent in a UPC member state. So the infringement occurred, for example, in Germany, then it is clear that the UPC has jurisdiction in that situation, provided, of course, the patent has not been opted out. But it has also jurisdiction when the seat of the defendant is located in a UPC member state. And in this situation, for example, a company located in Germany, and in this situation, it is not only about infringement that occurred in the UPC member states, but it can also be infringement in other states of the European Patent Convention. For example, in Spain, which is not a UPC member state, but an EU member state, or for example, in UK, which is not an EU member state. And the court, under certain conditions, has also international jurisdiction when it is about a number of defendants, and only one of these defendants has its seat in the UPC member states, provided the claims are so closely connected that it is expedient to hear and decide the claims together to avoid the risk of irreconcilable judgments. And there are currently two decisions of the European Court of Justice that further clarify when there is such a close connection. But I'm not going into details because to save time. Now, the court has jurisdiction on infringement, but the court has also jurisdiction on revocation actions when it is about putting the validity of the patent into question with effect to everyone, erga omnes. But only when it is about the UPC member states, so to the extent that the European patent gives protection in the UPC member states. The UPC has no jurisdiction with regard to revocation actions to the extent a European patent gives protection in non-UPC member states. So what can the defendant in infringement action do when he or she wants to defend him or herself with regard to parts of a European patent that give protection outside the UPC countries? In that regard, one has to distinguish between EU member states that are non-UPC member states like Spain and countries that are no EU member states like, for example, the UK. In both situations, the defendant will have to file a revocation action in the respective national courts, so in the Spanish court or in the UK court. And what will be the effect for the infringement action that is pending in the UPC, for example, because the defendant has its seat in the UPC member state? In that situation, the UPC may think of staying proceedings in the UPC with regard, for example, to a revocation pending in the Spanish court, or with regard to a revocation pending in the UK court. However, the UPC has also jurisdiction to decide, not erga omnes, not with effect to everyone, not on a revocation action, but as a defense on the validity of a European patent with regard to countries that are not EU member states. And this has been clarified, what I explained to you, by a decision of the European Court of Justice that came out on the 25th of February of this year, and is currently very much debated what this means in all the details. And we already have some decisions of the Court of First Instance of the UPC, and we will further have to work on this and find out about this. Let me move on with regards to the numbers of actions that have been brought to the UPC. As you can see, between 1st June 2023 and 31st August 2025, 773 cases have been filed in the Court of First Instance. And a large part of these claims are, of course, actions for infringement, but also we have seen filing of counterclaims for revocation, actions for revocations, and also requests for provisional measures, in particular provisional injunctions. Let me continue with the composition of the panels that are deciding. There are two characteristics. The one is that the panels, as to the legally qualified judges, is always composed international, meaning the judges coming from different countries. And that, of course, is in line with the idea of the UPC as a court shared by a number of member states. And the second point I would like to mention is that in most of the cases, the legally qualified judges are joined by a technically qualified judge. So that is different, as far as I understand the system here in Japan with the IP High Court, where there are technical advisors. In the UPC, they are judges. So they have a voting right like a legally qualified judge. And they have a background either as a national technically qualified judge, there are some countries that have national technically qualified judges, or they can be practitioners, meaning patent attorneys, or they can be retired members of boards of appeal of the EPO, for example. And with regard to practitioners, there is it's always made sure that there is no conflict of interest. I'm not going to details, but this is always checked before a technically qualified judge is assigned to a panel. Final point I'd like to make is about language of proceedings. Well, this is an international court, and in Europe we have many languages. In principle, all the local divisions offer to the claimant the choice either between the local official language, for example, if it is the local division in Paris, then the claimant can choose French, or, and this is true for all the local divisions, alternatively English. So if you go to a German division in Munich, it is German or English. In Paris, it is French or English. And in Milan, it is Italian or English. What does it mean in practice? That you can see from this slide. You see the pie, and you see that English is by far the most important language used as language of proceedings. However, German also plays a significant role, and there are a few more languages that are used, but not that often. And if I should tell you about a trend, I could say that it is currently becoming more and more English as a language of proceedings, and the part of the German proceedings is decreasing slowly, but it is decreasing. And this is quite interesting because all the member states, none of the current participating member states has English as an official language. So that gets everyone on the same level playing field. And that is, gives you an idea, this slide, about how the local divisions or the courts look like. In the first row, you see the regional division in the building of the regional division in Stockholm. Second is the building where the Vienna local division is located. Next one is where the Hamburg local division is located. Next one, you may guess, it is the local and central division in Paris. The middle one is the Court of Appeal in Luxembourg, a bit futuristic building. And finally, it is the local division and central division in Milan. And with this, I'd like to conclude my talk. Thank you very much.
グラビンスキー長官、ありがとうございました。それでは次に、米国連邦巡回区控訴裁判所のチェン裁判官、よろしくお願いします。
Konnichiwa. Thank you. I want to give my thanks to the hosts and organizers of today's conference, the Supreme Court of Japan, the IP High Court, the Ministry of Justice, JPO, and the lawyer groups. It's my honor to be here as the representative of the U.S. Court of Appeals for the Federal Circuit. And congratulations to the IP High Court on their 20th anniversary. We understand that this is not just a world-class economy in Japan, but it's also an important center of innovation. And so it's essential not only to Japan, but also everyone that Japan have an effective set of IP laws and enforcement of those IP laws. So I congratulate the IP High Court, and I look forward to seeing and watching your continued success. Now, the Court of Appeals for the Federal Circuit is now 43 years old. So if I can borrow President Grabinski's analogy, if the UPC is like a little toddler and the IP High Court is like a young, strong adult, we, the Federal Circuit, are like a middle-aged man with perhaps getting a round, soft tummy. Maybe we have some maturity, but it's also important for us to be mindful of needing to adapt to change, and there has been quite a bit of change. As for the Federal Circuit itself, it hasn't really structurally changed very much in the past 43 years. We continue to have 12 active full-time judges and a handful of senior judges that work a part-time schedule. Just as in 1982, the Federal Circuit has exclusive nationwide jurisdiction, appellate jurisdiction over patent law, which means if there's a trial, a patent infringement trial in Seattle or Los Angeles or Dallas or Chicago or Atlanta or Washington, D.C., the appeal will not go to one of our regional circuits. Instead, the appeal of that patent infringement action, they will all come to Washington, D.C., to the Federal Circuit. And likewise, we at the Federal Circuit also hear appeals directly from the USPTO administrative boards, both the Patent Trial and Appeal Board and the Trademark Trial and Appeal Board. So in this way, the Federal Circuit looks very similar to Japan's IP High Court. But over the past 20 years, the United States has experienced a considerable amount of change in its patent laws. I think if an American patent lawyer went to sleep in 2005 and woke up today, I don't think that American patent lawyer would recognize the patent system in the United States. I'll highlight a few key developments. I'm already running out of time. The first really crucial thing I think that's important for an international audience to understand is that our Supreme Court has become re-engaged with intellectual property law matters over the past 20 years. If you look at the first 20 years of the Federal Circuit's existence, really 23 years, from 1982 to 2005, the Supreme Court was not engaged in intellectual property law issues at all, really. And we could wonder why that is so, but I think part of the reason was because the Supreme Court saw there was a brand new specialized appellate court called the Federal Circuit that was going to be handling patent law issues and wanted to wait and see and give room and time for the Federal Circuit to develop a nationwide uniform body of patent law. I think a second reason is probably that the Supreme Court came to recognize about 20 years ago how important and consequential patents are and intellectual property is to the economy and really to American society. And so for those kinds of reasons, about 20 years ago, the Supreme Court got involved. And I think the first case I want to highlight is the eBay versus Merck Exchange case. This is the Supreme Court case 19 years ago that ended the presumption of permanent injunctions for patent owners who prevailed in a patent infringement lawsuit. Now trial courts apply the traditional equity factors that apply any time a plaintiff in a American lawsuit is seeking an injunction. And so this applies not just in patent cases, but any injunction case. So as you can see on the slide, it's irreparable injury, whether the plaintiff has inadequate legal remedies, the balance of hardships between the plaintiff and defendant, and what is in the public interest. And now with these factors in consideration, the result has been much fewer injunctions are now granted in the United States, even when a plaintiff in a patent infringement lawsuit wins an infringement verdict and survives a validity challenge, particularly when the plaintiff is not practicing its own patented technology. In those particular circumstances, when the plaintiff is a quote-unquote non-practicing entity, it's very unlikely that such a plaintiff can get an injunction. And this has really changed the dynamic between plaintiffs and defendants, just in terms of trying to negotiate settlements. As you may know, really only 1% of all patent infringement lawsuits ultimately go to trial in the United States. They almost all settle. And so now the settlement equation since eBay has changed somewhat. And then the KSR opinion, I'm already almost out of time, is about non-obviousness. I think other jurisdictions might call it inventive step. And once again, the Federal Circuit had a very bright line rule, just as it had with injunctions. In the Federal Circuit for the longest time would grant an injunction or would uphold an injunction for any plaintiff in a patent infringement lawsuit that won at trial. Now, thanks to eBay, it's not rare, but it's much less common. And then KSR, the Federal Circuit had a bright line rule, a bright line test for assessing obviousness. And what the Supreme Court did is say, no, we don't want any bright line tests. We want a more flexible inquiry, and that was KSR. This is another critical substantive area of patent law, patent eligibility. As you can see, the Supreme Court took 4 cases in a very short period of time, and that is highly unusual for the Supreme Court to take any one particular area of the law and then repeatedly consider it in just a period of 4 years. And what we have now is what I'll call the abstract idea test, where we now have to ask ourselves, for purposes of whether a patent claim is even eligible for the patent system, is the claim directed to an abstract idea, or is the claim directed to an inventive concept? I don't have the time right now to try to explain all of that. It's actually very complicated and controversial. But what I will tell you is that when district courts evaluate a Section 101 question for a patent claim, those district court decisions generally do get affirmed by the Federal Circuit. So at least the courts seem to have a basic understanding on how to apply this new area of the law, but it's still very controversial in the United States. And so the theme here with the Supreme Court is that, as I said earlier, the Supreme Court does not want the law to have a lot of bright line rules. The Supreme Court has a different philosophy when it comes to approach to the development of the law, whether it's patent law or any other area of the law. They want courts to use and apply flexible factors and other considerations and use their judgment in order to decide any one particular case. And I think district court judges, federal circuit judges can handle that okay, but it's the 8,000 patent examiners that have a much harder time in trying to deal with this new trend in Supreme Court law and Supreme Court intervention in US patent law. I'm out of time, but I can't ignore these cancellation proceedings that are at the PTAB now at the USPTO. These were created in 2011 by Congress, and they've been extremely popular in the United States for companies to challenge other patents through these administrative cancellation proceedings. As you can see, a lot of these proceedings have ended up invalidating a lot of patents in the United States, and so it's been a new weapon for defendants. But I think what we've also learned from these cancellation proceedings is that maybe we need the USPTO to do a better job of initial examination. Now, this is not an appropriate statistic to use to try to judge the quality of United States patents because there's a lot of factors that get mixed in, but nevertheless, it's a little bit of a window on why, in my opinion, the USPTO should try to focus more, and maybe with the advent of AI with examination processes, perhaps that'll be an improvement. But the one warning I want to say is that the new administration at the USPTO has been clearly this year looking to deny more of these types of proceedings. And what the result of that will be is really to force more defendants to have to seek to invalidate patents in district court rather than through the USPTO, unless a party wants to use a re-examination, which still is a viable option. There's a concentration of patent litigation. I think most people understand this. Most lawsuits are filed either in Texas, California, or Delaware. I think there's advantages to that because judges in those districts accumulate a lot of knowledge and experience with patent law, but there are dangers when you concentrate cases in just a few areas because you're always worried about bias and things like that for certain district courts to try to attract cases. And then finally, modernizing operations. Just like every other court around the world, we now use electronic filing. We do permit video arguments at times, and we in the US judiciary are thinking and talking with each other about AI and what generative AI means for us inside the courts, AI-generated evidence that can be introduced in litigation, and whether AI, like I said, can help improve patent examination. I'll stop there. Thank you very much.
チェン裁判官、ありがとうございました。海外ゲストの皆様、素晴らしいプレゼンテーションをありがとうございました。それではここからですね、残りの時間30分強ですがを使って意見交換をしたいと思います。まずはですね、今の日本の知財高裁特許庁、それから海外の裁判所でのこの20年間の活動発展を見ていただいてのですね、利用者の立場からの、感想というものをですね、弁護士の相良先生とそれから弁理士の黒川先生からいただきたいと思います。それでは相良先生、よろしくお願いします。
はい、ありがとうございます。私、知財高裁とともにJCIP を共催しております日弁連知財センターや、弁護士知財ネットの一員としてJCIP に何度か関与させていただきましたので、まずはこの本日の JCIP に至るまでの知財高裁、裁判所の皆様の継続的なご尽力に、心から敬意を表したいと思います。こうして年に1回実際に海外の実務家の方をお招きして、知財の共通テーマを話し合う機会があるということは、この20年の中でも大きな進歩だなと感じております。 それから、この20年間、ユーザーとしていろいろ進化を感じる点というのは数多くあるのですが、まず1点目はその審理の迅速、特に審決取り消し訴訟などにおける、審理の迅速化や充実化という点を挙げたいと思います。私先ほどのグラビンスキー判事やチェーン判事の例えでいきますと、知財高裁よりちょっと年上ぐらいの若者ぐらいの弁護士なんです。年はもっと上ですけど、で知財高裁ができる直前ぐらいの時期に、審決取り消し訴訟を経験しますと、判決が本当に忘れた頃に出るという時代があったんですけれども、今やその審理の期間が7から10ヶ月程度になって非常に早くなったと思います。また双方がパワーポイントを使って技術説明を行うというのも当たり前になりまして、非常に審理の進め方もスマートになり、審理の充実化も果たされているなという点を感じます。2点目はやはりウェブサイトの情報公開の充実という点を挙げたいと思います。ほぼ全件と言っていいでしょうか。裁判例が迅速に公開される点、さらに知財高裁においてはその重要な事件について日本語と英語で要旨を公開してくださっているという点は非常にありがたいことで素晴らしいことだなというふうに感じております。このような情報開示によって裁判所の判断の透明性が増したという声もよく聞いております。それからやはりデジタル化が、ここ数年の動きではありますが、デジタル化というのは非常に実務へのインパクトが大きいなというふうに感じております。せっかく新しいビジネスコードできたところではありますが、ウェブ記述が可能になりまして、審理の迅速化にもつながっているように思いますし、来年5月以降は訴状の電子提出もついに可能になりますので、さらに利便性が加速することを期待しております。それから先ほど各国の裁判官からご紹介いただきましたプレゼン拝聴いたしまして、本当に韓国ではデジタル化目覚ましいなというところと、国際インターナショナルディビジョンの存在やら、5倍の懲罰的損害賠償制度といった大胆な制度改革がスピーディーに行われているということに非常に感銘を受けました。それから UPC は本当に各国のさまざまな利害を調整して統一的な制度にまとめ上げられたことに心より敬意を表したいと思いますし、もう満を持してスタートされてあっという間に773件ものケースが継続しているということで、ここ日本におりましても大変な活気を感じているところです。非常にスピーディーな手続きと聞いておりますので、裁判例の蓄積も早いかと思います。今後の裁判例の蓄積にも注目したいと思います。それから米国の制度は本当にディスカバリーやら陪審制やら、日本と裁判制度の違いが多く非常に興味深い一方で、電子化がかなり以前から進んでいる一方、依然としてその対面の手続きが重視されているという点も、これからデジタル化を進める日本にとって示唆に富むように感じました。また AI の活用ということももうすでにだいぶ話されているということも非常に感銘を受けました。簡単ですが以上です。
相良先生、ありがとうございました。それでは次に弁理士の黒川先生、お願いします。
はい、ありがとうございます。私は知財高裁設立の6ヶ月前から3年間裁判所の調査官を務めさせていただいておりました。お世話になりました知財高裁の20周年記念をお祝い申し上げますとともに、この記念シンポジウムで発言の機会をいただけることに感謝をしております。知財高裁の設立当時は連日ですね、国内外から官民を問わず多くの見学者が調査官室にも足を運ばれておりました。そこでは大変多くのエールをいただきました。このエールに応えるべく緻密な調査をさせていただいたことを思い出します。 任官終了後は、利用者といたしまして、特に審決取り消し訴訟及び侵害訴訟の代理人としての感想ということになりますが、技術が高度化、複雑している中で、迅速かつ緻密なご判断、利用者にとりまして、予見可能性が高いご判断をいただいているということに感謝をしております。特に第5義事件は、その選定と審理に大変大きな労力を伴うことを存じ上げておりますが、この20年で16件というハイペースで判決を出されており、敬意を表するところでございます。第5義判決の中には、特許庁の審査審判実務に大きな影響を与えるものもございます。例えば、サポート要件、補正要件などについて、具体的な判断の指針を示していただき、利用者、我々の予見可能性が高まっているということが非常にありがたいというふうに感じております。先ほど特許庁の取り組みについてご説明をいただきました。審査の迅速化、効率化、国際調和などさまざまな施策を取られ、目標を達成されているということに敬意を表します。いずれの施策も日本弁理士会を含めました利用者の意見を聞きながら進めていただき、感謝を申し上げるところでもございます。そして各国の裁判官から最近の状況をご説明いただきました。韓国は電子訴訟制度が迅速かつ広範に進んでいるということに大変驚いております。特にユーザーにとりましては、電子記録ビューアーの閲覧、こちらの利便性が高いと考えております。UPC はまず多くの困難を乗り越えまして、統一特許裁判所の設立に至ったことに敬服いたしております。多くの日本企業にとりましては、英語で裁判をできること、そして迅速に専門性が担保されました UPC 判決が、複数の加盟国で一斉に効力を持つということは、日本の利用者にとりましても、さまざまな負担軽減となるというふうに考えてございます。米国についてご紹介いただきました判決は、いずれも柔軟性のある明確な基準が示されておりまして、その点でありがたいと考えております。また、IPR および PGR の導入も、PTAB の設立と合わせまして、利用者による手続きの選択の幅が広がるとともに、特許の有効性の検討についても予見可能性が高まったと考えてございます。最後でございますが、これからも JCIP を通じました国際交流を継続していただきたくお願いを申し上げます。日本弁理士会も引き続き諸外国の官庁、代理人団体などと交流を重ねていく所存でございます。私からは以上でございます。ありがとうございます。
黒川先生、ありがとうございました。パネリストの皆様、有益な情報、コメントですね、どうもありがとうございました。また、知財高裁のですね、20周年というですね、記念へのですね、ご配慮もいただきまして、ありがとうございます。それではですね、時間もだんだん迫ってきておりますので、ここで、次のテーマにですね、移らせていただきたいというふうに思います。次のテーマは、知財分野の専門裁判所が果たす役割になります。ここではパネリストの皆さんから知財分野の専門裁判所がどのような役割を果たすべきかについて意見をいただきたいというふうに思います。大変大きなテーマではありますが、この話題は明日の JCIP2025 の特許庁パート、それから裁判所パートが明日行われるんですが、そこへの架け橋にもなるようなテーマですので、こちらについてご意見いただきたいと思います。それから知財分野といっても実はさまざまな分野が含まれることになりますけれども、本日のパネルディスカッションではですね、特許分野ですね、特許分野を念頭に意見交換ができればいいなというふうに思っております。それから野中審判部長におかれましてはですね、知財行政ですねを担当する特許庁の果たすべき役割もご意見をいただきまして、それから相良先生と黒川先生におかれましては、利用者の立場ですね、利用者の側からの視点、そういったですねご意見もいただければ幸いです。それではまず知財高裁のですね増田部長、よろしくお願いします。
知財高裁の増田です。よろしくお願いいたします。 このパネルディスカッションの冒頭に、本田所長から知財高裁の20年の歩みについて基調講演がありましたが、知財高裁では設立以来、知財事件の適正迅速な処理を通じて、社会におけるスタンダードセッターとしての役割を果たせるよう努力してまいりました。この点については、先ほど各国の裁判官からこの間における各裁判所での発展状況についてお話がありましたが、それぞれの国のあるいは地域の実情に応じたさまざまな工夫がされているというふうに感じております。知財高裁は知財事件という専門性の非常に高い事件を適切に判断するために専門的知見を高めることが求められています。技術の進歩が加速している現代において、この点の重要性はますます高まっていると思います。先ほどのハン委員長のお話では、韓国知的財産高等法院では、我が国の裁判所調査官や専門委員に似た制度があり、また専門家承認も活用されているというお話でした。また、グラビンスキー長官のお話では、UPC には技術裁判官という制度があるようです。こうした各裁判所の制度も専門家に対応しようとする問題意識の表れだと思っております。知財高裁では裁判所調査官と専門委員という2つの制度を活用し、専門的知見を高めております。これらの制度は本田所長の基調講演にもありましたように、これまでおおむね順調に運用されていると思っておりますが、もちろんさらに改善すべきところはあると思っております。この議論については明日の裁判所パートでも取り上げられているというふうに聞いておりますので、ここでさらに深掘りをした議論がされることと思います。社会や経済に大きな影響を与えることの多い知財事件を扱う裁判所としては、自らが行う判断の社会的インパクトへの配慮も必要だと思います。知財高裁では通常の裁判官3名の合議体による判断のほかに、5人の裁判官により審議判断を行う大合議制度がありまして、これによってより慎重に規範性の高い判決を行うことができていると思っております。また、特許法の改正により、特許権侵害訴訟においては、第三者意見募集制度を活用することができ、事件における判断が社会においてどのようなインパクトを持つのか、裁判所において考える機会を得ることができるようになっています。この第三者意見募集制度についても、明日の裁判所パートで議論がされるというふうに聞いておりますので、そこでの議論がさらに深められることを期待しております。最後にデジタル化の流れについても言及しておかなければならないと思います。先ほどの本田所長の基調講演にもありましたが、我が国の裁判所では現在、裁判手続きのデジタル化のために鋭意取り組んでいるところでありますが、先ほどのハン委員長のお話をお聞きしますと、韓国においてはデジタル化が非常に進んでいるというふうに感じました。我が国も見習うところが多いと思います。知財事件を扱う専門裁判所においては、技術革新の目まぐるしい時代の要請に応えられるよう、しっかりとした判断を行うことが必要です。そのためには、各裁判官、裁判所職員が現状に満足することなく、より良い知財司法サービスを提供するために一体となって努力することが重要だと思います。私の方は簡単ですが、以上です。
増田部長、ありがとうございました。それでは次に、海外の裁判官の皆さんから、知財分野の専門裁判所が果たす役割についてご意見をお伺いしたいと思います。まずは韓国の知的財産高等法院のハン委員長、よろしくお願いします。
네, 말씀드리겠습니다. IP 전문법원 역할에 관해서 간략하게 말씀드리겠습니다. 잘 아시는 바와 같이 법원은 언제나 적정하고 신속 공정한 재판을 해야 합니다. IP 법원 역시 IP 재판에 대한 전문성을 갖고 적정하고 신속 공정한 재판을 해야 함은 물론입니다. 나아가 IP 법원은 국가의 경제, 사회 및 문화 등의 발전과 국민의 삶의 질 향상이 이루어질 수 있는 재판을 해야 한다고 생각합니다. 국가 정책이나 사회 발전 수준을 충분히 이해하고 산업계 동향이나 요구를 경청해야 합니다. 그래야만 국가 산업 및 문화가 지속적으로 발전하고 모든 국민이 그 풍요를 누릴 수 있습니다. 이를 위해서 IP법원은 IP에 대한 적정한 보호를 통해 권리자의 이익과 경쟁자 또는 공중의 이익이 조화되는 재판을 할 필요가 있습니다. IP법원은 과도한 보호는 후속 혁신을 저해하고 과소한 보호는 혁신의 동기를 약화시킨다는 점을 깊이 인식하고 IP 권리자와 경쟁자가 시장에서 공존할 수 있는 환경을 만들어줘야 합니다. 아울러 기업이 법적 위험을 합리적으로 예측할 수 있고 IP 분쟁에 대한 각국의 판결이 모순되지 않는 재판을 할 필요가 있습니다. 이를 통하여 기업은 계속하여 혁신을 추구하고 사회 발전에 이바지할 수 있습니다. 이와 관련하여 저는 각국의 IP 법원이 교류를 확대하고 협력하는 것이 중요하다는 점을 강조하고 싶습니다. 경험을 서로 나누고 강점을 서로 배우며 미래의 도전에 함께 대응하는 노력을 할 필요가 있습니다. 이상으로 제 말씀을 마무리하겠습니다. 감사합니다.
ハン委員長ありがとうございました。それでは次に、米国連邦準会区控訴裁判所のチェン裁判官、知財分野の専門裁判所が果たす役割についてご意見をお願いします。
Hello? Okay, thank you. The role of intellectual property specialized courts, it's a complicated question, but I think one of the first things we have to think about is the way we are able to communicate our opinions effectively to the public and also to all the other courts. Because the other courts in the United States are all generalist courts that read our opinions, like the district courts and the Supreme Court. So in many ways, I think it's important for a specialized court which understands the technical areas of their subject matter very, very well, that such a court is at the same time able to communicate all of that technical legal subject matter to generalists that are not specialized in this same area. And I'm talking about patent law right now. So that's an important responsibility because it seems like when you look at the recent history of Supreme Court reversals of Federal Circuit opinions, perhaps one of the problems there was that the Federal Circuit failed to effectively communicate the reasons for why the law developed the way it had at the Federal Circuit from 1982 to 2005, and therefore the Supreme Court couldn't completely appreciate the intentions and point of view of the Federal Circuit. So I think being able to be an effective communicator and getting into a dialogue with the generalist courts and as well as the public matters, and then for that matter, the USPTO. USPTO has a huge responsibility, as I said. They receive hundreds of thousands of patent applications a year. They have thousands of patent examiners. Very few of them have law degrees. So as a Federal Circuit judge, we have to keep in mind that the more complicated we make the law, the harder it will be for the USPTO to administer that law inside the agency. So I think that's an important sensitivity. In terms of larger policy goals of trying to decide how best to promote the economy or how best to promote innovation. I think that is something that the Federal Circuit is sensitive to, and we, I think, did have some kind of a role in why the United States economy improved after the creation of the Federal Circuit. I think a lot of people believe that. But at the same time, what's more important, I think, is the rule of law. It's our responsibility to follow precedent and apply it regularly with uniformity and predictability. And then if the true policymakers, which are members of Congress, see a problem with that precedent, then they have the opportunity and perhaps responsibility then to reform the laws to put patent law in a better direction. And in a way, the Supreme Court also has that responsibility as well. The Federal Circuit does have some discretion, I'll say, when they act as a full court to revise the law if they see that the law is not going in the correct direction or in the direction that the Federal Circuit had originally intended. But at the same time, it's important for a specialized court to also have some humility and not writing opinions too broadly, because opinions that we issue have nationwide consequence. We don't have other circuit courts, other appellate courts in the United States that are also writing and thinking about patent law. So we don't always know what's around the corner, what the consequences are of an opinion we write. So therefore, it's I think important to have some humility in terms of the scope of an opinion that a Federal Circuit judge writes or a specialized court judge writes. That's my opinion.
チェン裁判官、ありがとうございました。それでは次に、欧州統一特許控訴裁判所のグラビンスキー長官、よろしくお願いします。
Thank you very much. I think for a judge, there are two things essential. The first thing is to make sure that the right to be heard is respected. That means that arguments of a party in front of a judge as part of a proceeding before a court, that these arguments are heard and understood. And it is, of course, also important that the judges know about the law and to apply once they have heard and identified the facts that were brought in front of the judges. And the European approach to this in the field of particularly patent law, but also to quite some extent IP law in general, is that there are specialist courts, or at least specialist parts in the general courts that deal with these litigation. For example, in Germany, with regard to infringement, it is district courts that have jurisdiction, but only a few, not all. And in the district court, it is a specialized division that takes care of IP litigation and particular patent litigation. And there is, when it comes to validity, even a court that is a federal patent court. So one court that decides on this, a specialist court. In France, for example, all the patent cases on the national level go to one court, the Paris court. Before, 20, 30 years ago, it was different, but after a revision of the French law, it developed in that direction. And the same is true for Italy. There's only a few district courts that have the jurisdiction to decide in patent cases. And now I could go on to Sweden, to other European countries. And as there is an interest in Europe to have a court also on the European level, in parallel to the single market concept of the European Union. There has been a common court dealing with patent cases that has been discussed essentially since the 1950, the 50s of the last century, and it finally became a reality with the UPC. So there's quite a strong belief in Europe that specialist courts should deal with these with patent cases because of the complexity of the cases. It is about technology. Technology is developing all the time, and judges have to be open to it and have to understand about the cases. And it is, in principle, it is. I think any judge can understand what a technology case is about, but it would certainly take a judge who is used to do with these cases much easier, much more efficient to deal with these cases, rather than a judge who has really to start working on the first case, and then the next case again is a general civil law case. So I think this is the reason why in Europe there's it's more the specialist court approach. At the same token, I would say it is, of course, important also for the specialist judges that they do not forget about general principles that underlying all fields of law. So a contact and an exchange of minds with judges in the other fields of particular civil law is, of course, also important. That they do not start to develop their own law that is no longer in touch with the general tendencies in civil law. But there are ways to make sure that this is going to happen by exchange of views, by reading not only as a patent judge, not only reading patent decisions, but also decisions in other fields of law. And of course also by international exchange like this one, to learn also other approaches, how this works. So in general, the European approach is in the direction of specialist courts, and they justify because it's a very particular area, it's more efficient, but they should not lose touch with the other fields of law at the same time, and that's also important. Thank you.
グラビンスキー長官、ありがとうございました。皆様大変示唆に富む、ご意見いただきましてですね、ありがとうございました。それでは次にですね、野中審判部長に、知財行政を担当する特許庁が果たす役割などについてご意見をいただきたいと思います。よろしくお願いします。
はい、ありがとうございます。私に与えられたお題はちょっと裁判所とは違って、行政機関としての特許庁の役割ということでございます。で本日私のプレゼンテーションの中でも長めの時間をとって特許審査の迅速化、それから質の向上という話をさせていただいたようにですね、我々行政庁としてはですね、まず特許制度の第一段階として、権利の設定を迅速的確に行うと、これが何より大事だと考えております。特に特許権等ですね、強力な独占権でありますから、後に裁判所で争っていただくという手段があるとはしてもですね、この段階できちっとした、権利設定ができるようにということで、我々の持っている、技術的観点、法律的知識も、活用しながら、また本日本田所長、増田部長からもスタンダードセッターという話ありましたけれども、裁判所で示していただいたスタンダードに従いながら、的確な審査を行って権利付与を行うと、これが何より特許庁の大事な役割と思っております。またその後審判部の手続きもあります。審査部で不満の結果に不満のある方、それから権利の有効性に疑義がある場合、争っていただく行政段階の最後の手続きになりますので、こちらではより厳格な手続き、合議体を使って複数の審判官で適切な判断を行っていくということをしっかりやろうと考えております。また行政庁特有というところではですね、実際に設定された権利を有効に活用していただくと、本日もイノベーションの創出支援という話をさせていただきましたけれども、こういう形の支援をしていくところは行政庁ならではの役割と考えておりますので、今後ますますこういうところを充実させていきたいと思っております。 また今日の JCIP もそうですけれども、海外の方と交流をして海外の情報をしっかり集めて、それを咀嚼して日本のユーザーの皆様に伝えていくというところもですね、我々行政庁の重要な役割だというふうに考えておりますので、今後もこういうところですね JPO もしっかり貢献していきたいと考えております。知的財産を支える行政機関として東京庁としては、裁判所も含めた関係者の皆様と協力しながらですね、ユーザーの皆様の期待に応えられるようにしっかりやっていきたいと考えております。私が以上です。
野中審判部長、ありがとうございました。それでは裁判手続き、特許庁での手続きの利用者の立場からということで、まずは相良先生、お願いします。
はい、ごく簡単に申し上げますけれども、これまでの経験上ですね、日本には技術系の裁判官などはいらっしゃらないわけです。一部いらっしゃると思いますけど、結論についてすごく公正中立な判断がなされているというふうに感じております。世界の制度から見ると、調査官制度や専門員制度独特な面もありますけれども、制度を大きく変えるといったことよりもですね、審理の中で裁判官と当事者がよりインタラクティブに意見交換や質疑応答がなされることによって、専門的な事項の当事者間および裁判官の理解を深め、予測可能性が高まっていくのではないかというふうに思います。と同時に、知的財産の紛争、専門的な技術的な事項もあるわけですけれども、とはいえ紛争ですので、やはり裁判官の方にはですね、専門的な知識という以上に公正なリーガルマインドを持っていていただきたいなということは常々感じております。あと今日他国の制度などをご紹介いただいて、本当に日本の裁判もですね、より当事者が使いやすい例えば海外の専門家証人にウェブで尋問ができるとか、そういったような利便性が向上していくといいなというふうに思いました。以上です。
相良先生、ありがとうございました。それでは弁理士の視点からということで、黒川先生、よろしくお願いします。
はい、ありがとうございます。各国ともですね、先ほどいろいろお話ございましたけれども、知財分野の専門裁判所としてさまざまなお考えに基づいてさまざまな取り組みをされ、またこれからされようとしているということに敬意を表するとともに、できれば利用者の意見を聞きつつですね、より高い専門性への期待に応えていただきたいと考えてございます。技術専門性につきましては、技術的に妥当なご判断をいただきたいというふうに考えてございます。知財高裁におかれましては、調査官制度、専門員制度、先ほどご説明ございましたけれども、そして技術説明会、これらをバランスよく活用していただきながら、引き続き技術的に妥当なご判断をいただきたいというふうに考えてございます。あと、知財分野の専門裁判所が果たすべき役割ということで、こちら利用者の立場で申しますと、具体的な判断基準をお示しいただけるとありがたいなというふうに考えてございます。特に進歩性の検討は、どの国でも特許実務に携わる者が知るべきスタートでございますし、かつ永遠のテーマでもあると思います。進歩性につきまして、日本の知財高裁では動機づけの必要性について判事された事例ですとか、後事例の排除に関する事例もございました。これらはですね、具体的な基準を示しつつ、緻密なご判断をしていただいたというものがございます。これらの判決は特許庁における審査基準の改定につながるなど、実務に大きな影響を与えておりまして、それにより産業界の予見可能性が高まっております。米国における先ほどご紹介いただいた KSR 判決も柔軟な自明性分析が示された点で評価したいと考えております。以上でございます。
黒川先生、ありがとうございました。それでは大変名残惜しいのですが、そろそろ終わりの時間になってまいりましたので、このあたりで JCIP2025 初日前半の主催者合同企画を終わりにしたいと思います。 それでは最後になりますが、主催者を代表いたしまして、簡単に締めの挨拶をですね、いただきたいと思います。まずは知財高裁の増田部長、よろしくお願いします。
ありがとうございます。本日は知財高裁設立20周年を機会に、海外からベテランの裁判官の方々をお招きし、こうしたシンポジウムが開かれ、各国、各地域での知財司法、知財行政のこの20年の歩みも踏まえつつ、情報を共有し、意見交換をすることができたことは大変有意義なことであったと思います。それぞれ本国で大変お忙しい立場にありながら、海外からこのシンポジウムにお越しくださった韓国知的財産高等法院のハン院長、欧州統一特許裁判所控訴裁判所のグラビンスキー長官、米国連邦巡回区控訴裁判所のチェン裁判官におかれては、大変貴重な情報、ご意見をご教示いただき、本当にありがとうございました。相良先生、黒川先生で、特許庁の野中審判部長からは、知財高裁に対する応援のメッセージをいただいたというふうに思っています。ありがとうございました。皆さんと今日情報を共有し、意見交換をすることができましたことは、私自身大変刺激を受けましたし、このパネルディスカッションをこの会場で、またはウェブでご覧になっている多くの方々も、これからの我が国の知財司法が進むべき道がどうあるべきかということについて大きな示唆を得ることができたのではないかというふうに思っています。本日はどうもありがとうございました。
増田部長、ありがとうございました。それでは次に野中審判部長、よろしくお願いします。
はい、ありがとうございます。時間も限られておりますので、増田部長の方からですね、お話しいただいたこと、私も全く同じ思いで、各国から参加された方、また本日いらしていただいた方への感謝申し上げますけれども、詳細は省略をさせていただきます。で、また本日はですね、知財高裁設立20周年ということで、それに関連したテーマでしたけれども、私ども特許庁についてもですね、この特許庁の取り組みを振り返る機会をいただけたということで、大変感謝を申し上げます。で、本日は各国の知財司法についての話を、私自身も大変興味深く拝聴させていただきました。今後もこのような取り組みが行われていくということをですね、期待しております。また宣伝になりますけれども、明日 JSIP の2日目は特許庁パートになっております。各省の実務についてパネルディスカッションを行い、各国の相互理解がさらに深まることを楽しみにしておりますので、また明日のもしっかりご参加いただいてですね、ご期待いただければと思います。本日はありがとうございました。
野中審判部長、ありがとうございました。それでは以上をもちまして、主催者合同企画を終わりたいと思います。皆さんご清聴ありがとうございました。
以上でパネルディスカッション、知財分野の国際的動向、知財分野の専門裁判所が果たす役割を終了いたします。ご登壇の皆様、ありがとうございました。